All right, well, hello everyone, and welcome to another episode of GovCon Roundup Live. My name is Carroll Bernard. I am a co-founder here at Govology.com, and I'm joined by my co-host, Mr. Stephen Koprince. Hey, Stephen, how you doing today?
Hey, doing great, Carroll. How are you doing?
I'm doing good, man. Good to see you. Let's talk about our topic for the day. It's going to be on the state of the 8A program. Within this, we're going to talk about a lot. We're going to talk about suspensions. We're going to talk about appeals, getting into the program, what the heck's going on with the program today. So for anybody that might be new coming into the 8A program, doesn't have a lot of background or history, can you give just a really brief overview in a nutshell of what the 8A program is? What went wrong specifically in terms of why did the Supreme Court rule the way that the SBA was administering the program was unconstitutional? And that was, I think, in about 2023, correct?
And it wasn't a Supreme Court decision, but we'll talk about that in a second.
Oh, okay.
Another federal court, and that issued that decision.
Yeah, didn't go that high.
Didn't go that high, no, because no one ever appealed it.
So. Yeah, and then since then, what was the timeline? So since 2003, we saw some things starting to change and starting to happen, and then 2025, then 2026, we continue to see not only the effects of the follow-on from that decision, but the change in administration and some things that we're seeing here today. So you want to start off there?
Yeah, and there's a lot to unpack there. I'll try to make it quick. If we're going to get into the timeline, there's just been a lot that's really happened since kind of the middle of last year that we can talk about kind of one by one. But just let's take it back to that starting point kind of for those who are new. So it's called the 8A Business Development Program. It's the official name of the program. And it was a program created by Congress. So it's created by Congress, signed into law, part of the U.S. Code. And what it is intended to do is provide special opportunities for businesses that are owned and controlled by people who are considered both socially and economically disadvantaged. That's one category of 8A, or by certain entities that represent groups that are historically, socially, and economically disadvantaged, such as Indian tribes, Alaska Natives, or Native Hawaiians. And so what the program does is it has a structure under which the SBA then certifies companies that meet the criteria. And there's a lot of criteria as to what qualifies as economically disadvantaged. For example, for an individual, there's a net worth test. There are actually kind of two net worth tests. There's an income test, and then we got the social disadvantage side, which we'll talk about a little bit more in a second when we talk about that court case. And then you've got a whole bunch of other criteria in terms of the person has to show that they own at least 51% of the company. If they're an individual, they have to hold the highest officer position. They have to direct day-to-day operations. They have to have experience necessary to run the company, all these sorts of things. So we'll talk about the eligibility criteria in a moment, but they're pretty intense, strict eligibility criteria for entering this program. And then Native Hawaiians, Alaska Natives, and Indian tribes have a different set of criteria for how they would qualify their companies for the program. Why would anyone do this? It's because the 8A program carries certain contracting preferences. And so once you're certified by the SBA as an 8A company, you have a term of up to 9 years that you can hold that certification. You can't hold it forever. It's up to 9 years. You are eligible both for 8A set-aside contracts, and those are contracts that only 8A firms are eligible to compete for. And there are 4,000-ish 8A firms out there, and only so many of them do what your business does, right? So it can be a pretty small pool sometimes of bidders. It certainly narrows the pool from full and open, which is everybody or even all small businesses, down to just those certified 8A companies. So those are set-aside contracts. And then you have the opportunity to potentially be awarded sole source contracts, no bid type contracts, which the 8A program has a powerful sole source component. The SBA certification program, you're going to see many more sole source contracts awarded under the 8A program because of the way that's structured than under the Women-Owned Small Business Program, the Hub Zone program, or the Service Disabled Veteran-Owned Small Business Program. And we can get into the nuances of the structure if you want, but I'm not going to get into there right now, just to say that it's a powerful preference. You also have potential other benefits as well. For example, the SBA may help you with some business development assistance. The large prime contractors may be interested in being your mentor under a formal mentor-protege agreement, forming joint ventures, using you as a subcontractor to meet their prime contract subcontracting goals. So there are a lot of benefits that can flow to a company from 8A. The policy idea behind 8A is to find disadvantaged companies or companies owned by disadvantaged individuals and through this business development assistance over a period of 9 years, put them on an equal playing field with everybody else. So they can come out of there and then now compete for small business set-asides or unrestricted contracts, what have you, without that weight of disadvantage hanging over that underlying policy idea behind the program. So we'll talk about the Supreme Court, and then maybe want to pause and then before we get into the timeline of what's happened recently, it's not the Supreme Court, the federal court recently. So let's get back to the criteria for eligibility for the 8A program. So let's put aside the entity-owned companies right now. Those are the ones that are going to be owned by Alaska Native corporations, Native Hawaiian organizations, or Indian tribes. And we're going to focus now on just the quote-unquote standard 8A companies that are owned by individuals. So there are a number of eligibility criteria for that status. For example, you have to have what's called good character. If you're currently serving time in prison for murder one, then you don't qualify for good character, right? So there are a lot of criteria, but one of the most important criteria is what's called social disadvantage. What is social disadvantage? Well, if you read the 8A regulations, you as an individual can do two things to demonstrate your social disadvantage. One, you can demonstrate to the SBA's satisfaction that there is some objective characteristic about you, and that could be your race, it could be your gender, potentially your sexual orientation, potentially a disability, potentially religion, some objective characteristic about you that in your personal history has led to bias or discrimination against you, that has had a concrete impact, a real impact that has held you back in terms of your education, in terms of your experience in the workplace, working for others, and or in terms of your experience as a business owner. You, under the regulations, can do this, is show the SBA, look, here's a characteristic about me. I suffer from a disability, for example, and here are times where I was discriminated against because of that. Now, importantly, when you do that, you don't have to prove beyond a reasonable doubt that you were discriminated. It's just kind of a more likely than analysis, and the SBA is required to take your word for it, unless what you say is absolutely ludicrous or they have evidence that points in different directions. Your former boss doesn't have to admit that they discriminated against you for a promotion because you're a woman, for example. If you show facts that make it clear, hey, I was more qualified, I applied for the job, but they gave it to Bobby because Bobby's got to support a family or whatever, because of that some outdated norms about who's the breadwinner, that might be enough to prove it. So that's one way. You prove your individual social disadvantage. The second way under the regulations is literally just to be a member of a group that has historically suffered from discrimination, bias or discrimination in this country. You don't have to prove, if you're a member of one of these groups, or didn't have to prove under the regulation, that you personally had experienced bias or discrimination. That could be certain Asian Americans, Black Americans, certain Hispanic Americans, a group of that's literally listed in the regulation of groups of racial or ethnic identities. And so that was the piece that went to a federal court in 2023. It was a case called the Ultima case. And in that case, the federal judge said, look, to write a regulation or a statute, to write into the law in this country, a racial classification, you have to have like the highest level of need for that. You have to meet a really high threshold of proof as a matter of constitutionality to show that it's appropriate to literally put in the regulation a list of racial criteria and say, yeah, you qualify, you don't. And the judge said in this case, Congress, when it originally wrote this statute, and the SBA, when it implemented, it had not met that threshold. They had not demonstrated sufficient proof that they had reached the extraordinary need to write a racial classification into the law. And so the judge said that part of the 8A program, that part that said if you're a member of a group, you automatically meet the social disadvantage criteria, is unconstitutional. And so that's where that federal judge issued that ruling. The SBA could have chosen to appeal that ruling to the appropriate circuit court and then potentially up to the Supreme Court. The SBA chose not to do it. And I don't know the reasons why, but my guess is because they thought they would lose. And there's not a political motivation here either, because this is under the previous administration, which is not necessarily having the same political interest in rooting out DEI or whatever as the current administration. My guess is they thought they would lose. And I, for years, have thought, I don't know that SBA has the proof that they need to support this racial classification in the law. So that didn't mean the 8A program went away. All it means is that at that point, that path toward demonstrating social disadvantage was gone. In order to demonstrate social disadvantage after that court case, every individual applicant has to personally prove that they have some objective characteristic, whatever that was, about them, and that they had personally experienced incidents of bias or discrimination that had set them back in terms of their education, their workplace experience, or their business life.
Yeah, which is interesting because when I worked at the SBA back in around 2010, what was interesting is that when we would help firms apply for the 8A program and sit down with them, we would always actually have them complete the social disadvantage narrative.
So the SBA had been kind of inconsistent about that for a while. Sometimes they would, at points in time, they wanted a social disadvantage narrative, even from people who fit into one of those categories that said they were presumed. But then they stopped doing it for a while. Like I worked on many 8A applications with clients who fit in the presumed category, and all they had to do was essentially swear under penalty of law that they met that they fit in that category, and that was it. There was no narrative required because SBA said, well, that's belt and suspenders stuff. You already meet the presumption, so you're presumed that you're socially disadvantaged. You don't have to personally prove that you experienced those narratives. SBA always reserved the right to come back and say, no, we want you to prove it, basically. I'm like, wow, like it's, but that's what they were asking for sometimes instead of the narrative. And there were people who were getting in without the social disadvantage narrative based on swearing that they were part of a group that was socially disadvantaged. Sometimes the SBA did require more. They could ask for evidence that you held yourself out to the public as member of that group. And so some of these groups are based on national origin. So, hey, you're Pakistani American. Do you hold yourself out to the public that way? You have to supply evidence that, no, I belong to a Pakistani students group when I was in college or something. I'm not hiding it from anybody. But those are kind of case by case basis. And sometimes all you had to do was check the box, sign the form under penalty of law, which is signed under penalty of perjury. So it's not an insignificant thing to be swearing to. And sometimes that was it under that presumption.
Yeah. So then, since then, now everybody has to submit the social disadvantage narrative, which, by the way, we're not going to go deep into what those entail to meet the eligibility. We have webinars on that. If you guys want to reach out to us, Stephen does a great webinar, and you're going to do another one with us in April on all of the certification programs. But what's interesting is that it was always available for any contractor that basically had instances of discrimination, not only the minorities. So basically, the regulation would have the presumptive groups of the minorities, but it said if you didn't fall into that group and you've received bias or discrimination and you meet the definitions, you can also apply, and then they would consider it on a case-by-case basis. Is that correct?
Yeah, that's exactly it. And I think it's a misconception about the 8A program and that it's a program, quote unquote, for minorities. And I think in the past, there were some times where SBA made it really hard to get in on that track, and other times where it was less hard as a matter of practice. But in my experience working with many 8A applicants, I helped many Caucasian women get into the 8A program. This is before the current administration. This is before many Caucasian women get their businesses into the program, showing that they had been discriminated against on the basis of being a woman. And I helped a number of disabled veteran Caucasian men get into the program, showing that on the basis of their disability, they had been discriminated against and that they met the social disadvantage criteria. So it's never been a program, quote unquote, for minorities, but it was, to be honest, a program in which members of certain minority groups had a leg up with respect to one of the many eligibility criteria. Because there's social disadvantage, economic disadvantage, there's good character, there's net worth, there's income, there's management control. There's a lot of eligibility criteria. But on the social disadvantage side, members of certain groups didn't have to sweat out the narrative part. They didn't have to come up with the times they'd been discriminated against necessarily, or compile all that information or convince somebody that they were socially disadvantaged. They in many cases, just had to attest that they were a member of the group. So that's where minorities had a leg up with respect to one of the many eligibility criteria, but it was never a gatekeeping criteria. It was never intended to be that way. It was just an easier path with respect to that one part of the application.
Yeah, so there's a couple of other things I want to circle back with, and specifically what happened at the end of 2025 and then what's happening right now. But before I get to that, where is the program today just in terms of the definitions for the criteria? I don't think that has changed in law, but we have seen some information that was posted by the SBA in January talking about some of the Biden era, which I don't know what really that meant, because this has been going on for many years. I mean, this program was in place even before President Biden was president, but now it speaks to something about if you were discriminated against by Biden era DEI or set asides or some of these other things, you are eligible. How does that work, I guess? Can you help me understand that in terms of
Yeah.
one, it's not law, it's something that was put out there, but are they looking to change law? Has the law changed any? Are they going to change the law to expand the definition? What are you seeing in this?
Yeah, and so yeah, and I don't have any inside information. SBA unfortunately doesn't call me and tell me what they're doing. I mean, I do agree that some of these SBA press releases, just the way they're writing them right now, you have to kind of parse through them a bit and try to take out kind of the political rhetoric. But you kind of have to mentally filter some of that, I think, and get to the substance, because there's a lot of that goes on. And yes, like we say Biden era DEI, but they were doing this. The program was run the same way in the first Trump administration, right? But they're trying to go a different direction here. And so I think we have to get down to brass tacks, though. And the thing that the major change that's happened is really, is the ultimate case. It's that federal court case that said there is no more presumption of disadvantage for anybody based on their race or ethnicity or national origin, because it's unconstitutional. And so I think that some of the angst over the 8A program is coming potentially from folks who don't understand that case and what it meant. And it's sort of reasonable in a way, because that part of the regulation was declared, and statute was declared unconstitutional. It's unenforceable. The SBA has not enforced it in almost 3 years now, but it's still on the books. And so if you read the 8A regulations, you might say, wow, they've just listed out a bunch of categories of race and ethnicity. This is a DEI program like I've never seen before, without understanding that it's gone, that regulation is unenforceable. And so, yeah, I have heard that SBA is, as they should, and they probably should have done this earlier, planning to issue a regulation to wipe out the rule that the court has already said is unconstitutional, and that SBA decided not to appeal. Why that's taken 3 years, I don't know. Rulemaking can take a while.
Right.
But then you're simply repealing a rule that was declared unconstitutional. I don't know why that needs to be a delay.
So when you say get rid of it, do you mean go back to the regulation and just take out the piece that they had, like these groups have the presumptive disadvantage, and just make it everybody can apply if you've got discrimination or bias, but you just have to cite this instances?
Yeah, that's probably what it would look like, is they would just wipe out. I mean, and that may be some of the conversation that's going on, like, what do we as SBA have statutory authority to do here? One possibility, although I think this would require Congress to come in, would be just be to eliminate the concept of social disadvantage entirely. It's like, you know what, we're not comfortable with it. It's just going to be for economically disadvantaged businesses. You meet the net worth and income threshold, then you're in. And like 10 years ago, I predicted that was what was going to ultimately happen to this program because of the tension surrounding the social disadvantage criteria. But again, I don't know that SBA has the legal authority to do that, because the social disadvantage piece is part of the underlying statute. So they may be still considering what to do with that. But yeah, I think what they would need to do then is come in and strike the part of the regulation that says, it currently says there's two ways to become qualify as socially disadvantaged. One, prove it to you're presumed because of your membership in a group, and it would just eliminate that second item and say, no, everybody, there's only one way to qualify as socially disadvantaged, and that is to prove it. And then maybe you still don't like that as the administration, then you can potentially work with Congress to try to say, let's just turn this into a program for folks who are economically disadvantaged. Let's just not even worry about social disadvantage. And that would be potentially the next step that could be taken.
It'd be like, hey, it would be great if they expanded the definition out a bit, because the 8A program is a good program. Not only is it beneficial to the businesses that get into it, to use it as a springboard, because the biggest disadvantage everybody has coming in is the past performance and past experience disadvantage. Through the sole source contracts vehicle is a way for those small firms to get some of that, so that once they graduate, then they can actually go out and compete in the general small business marketplace, but even in full and open competition. So I think I'd like to see something like that, where it just opened it up to all, to allow more businesses, because there are a lot of disadvantages that are not taken into account, just beyond economic and social disadvantages that I think small businesses face in this marketplace.
Yeah, I mean, it has been a very successful program, and that's the thing, is it's been successful, and not everybody goes into that program succeeds, but a lot of companies have done exactly what the program was intended to do, which is get a foothold in the government contracting marketplace, build toward a place where they're successful, growing, and can compete for unrestricted contracts, or at least small business set-aside contracts, once they exit that 8A. So it really has been, and I've been there as companies, fledgling companies who now are massive businesses, 15 years later, have used that 8A program exactly as intended for a springboard. So I think especially as we're facing a world in which every year, almost like 14 of the last 15 years, the number of small business prime contractors has declined. Usually there's an increase in the dollars that are being awarded to small businesses, but the actual industrial base, the small business industrial base, has shrunk more than 50% over the last 50 years, more than 50%. So half the number of small businesses that are selling to the government now that did before. And there's a lot of factors that are responsible for that, from contract consolidations, things that aren't using these best-in-class vehicles, all these sorts of things, up to just the past performance conundrum that you mentioned, and how emphasis often on the kind of chicken and egg thing, where you really need government past performance to meet the criteria for past performance, or to get a good score on a past performance criteria, but you can't get government past performance unless you win a contract, so this chicken and egg thing. So there's a lot of reasons that could go into that, but having a program like 8A that was more available to companies that want to enter that federal market and want to be able to succeed and need to build that record of past performance, need to build that experience, maybe could help stem the tide here, where every year we're seeing fewer and fewer companies that are small businesses that are selling.
I want to talk about the status of sole source contracts right now, because you mentioned that as one of the benefits of the 8A program. It's the sole source authority within that program is not like any other program. It's basically the contracting officer doesn't have to write like a justification. They don't have to say there's like, I couldn't find 2 or 3 firms that could do this work, and they could just go right to the firm. Now that also benefits the government at the end of the year. And if you look at any 8A spending, you see a lot of 8A because the government's got the money. It's been all backlogged from the shutdowns and everything else, and then it gets released and it helps them expedite. So we're going to see how this plays out. But can you talk about the status of sole source right now? Because I think last year we saw a bill introduced to stop sole source contracting until the audit was done. But I don't think that bill has been passed. But there's been some people from Congress who've reached out to agencies saying not to award sole source contracts until the audit's done, which who knows when the audit's going to actually all get done. You have any insight on that?
Yeah, so just first things first, structurally, as I mentioned kind of at the outset, so the 8A program alone of the 4 major SBA certification programs, which includes also the Woman-Owned Small Business Program, HubZone, and the SDVSB, Service Disabled Veteran-Owned Small Business Program. The 8A program has the most powerful sole source component by far, and that's because the other 3 certification programs, while they allow sole source contracting, they only allow it at all dollar values when the contracting officer has no reasonable expectation that if they put this out for competition, they will get 2 or more offers from qualified, capable HubZone firms or SDVSBs or women-owned small businesses. And so the 8A program does not have that barrier. And there's differences at dollar values about what they've got to do here and there. But essentially, for a lot of 8A work, the contracting officer can say, look, I like 8A firm X. They've done good work for us before. We know them. Yeah, if I put this out on the street, I might get 10 other 8As who bid it, but it doesn't matter. I'm awarding the contract to firm X. And that's why you see the 8A dollar awards are so much higher than other certification programs. It's because structurally it's a much more powerful sole source ability that contracting officers have. And you're absolutely right, Carroll. At the end of the fiscal year, they really love it, because it's an easy way to award some of that money that's going to disappear if they don't obligate it by the end of the fiscal year. So, what I've always long said, and I'm saying more often now that we see kind of more attacks on the 8A program, is that, you don't benefit, you certainly don't benefit SDVOSBs by tearing down the 8A program or attacking the 8A program. What should be done, if you're an advocate for one of those other programs, is to equalize their sole source authority with the 8A authority. And that would take an act of Congress. Congress would have to step in and write that statute, but Congress could easily do that. Congress could say, look, we want to support veteran-owned small businesses, so we're going to change the sole source component of the SDVSB program to match the 8A program. And there's no reason Congress can't do that. You see these attacks on the 8A program saying it'll be good for veteran-owned businesses. Some say if we do less work with 8A firms, and yet there are more than 400 veteran-owned businesses that are 8A. Veteran-owned businesses got more than $2 billion from the 8A program in the last fiscal year for which we have data. So that's not helpful. What it would be helpful for those companies would be to expand that. So that sole source authority has come under some fire. I guess we never got to the full timeline, but one of the things that happened, I believe it was November, December, was Senator Joni Ernst of Iowa introduced a bill that would say we're going to put a halt on all sole source 8A awards until the SBA finishes this lengthy audit that it is detailed financial records. Those were due in January 19th. And so who knows when this audit will be complete, but SBA is going through fine tooth comb all the records that were submitted. And so Senator Ernst said, my bill would halt sole source contracts. We would require agencies to halt 8A sole source contracts indefinitely. That's what the bill says. That bill, to my knowledge, has not gone anywhere. It's out there. I don't think it has the support to pass both houses of Congress. That's just my guess. Senator Ernst also separately sent a letter to the head of each of the 22 federal agencies that use the 8A program, asking them to voluntarily pause 8A sole source contracts, because the bill would force the agencies to stop doing it, but the agencies on their own volition can just choose to stop using 8A sole source. There's nothing that requires them to use 8A sole source. It's just a convenient contracting tool that a lot of agencies like to use. However, I have seen some agencies that have issued their own statements expressing some 8A program skepticism or whatever, but none of them that I have seen said, yeah, we're actually following Senator Ernst's call to pause 8A sole source contracting, probably because in a lot of cases they're getting pushback from their contracting shops saying, no, that's really going to hurt us.
Yeah.
Like we need that tool in our toolbox. Why would we voluntarily give that up?
So what you're saying is that there's not an official, formal, legal prohibition to 8A sole source contracts. So you could expect to see some continuation of sole source contracts happening in this fiscal year.
You should, yeah. And so there's no prohibition on it. The Senator Ernst has put pressure on the agencies to not do that, of course, but the bill is not passed. So the bill is just hanging out in committee right now, which is where most bills die ultimately. And thousands of bills that are introduced every year, only a small fraction become law. And I have not seen the agency voluntarily say we're going to suspend sole source contracts. That doesn't mean that we'll necessarily not see any impact from this. I mean, I think realistically there is some sort of pressure on agencies to potentially reduce their 8A contracting, whether agencies feel that pressure or not, whether they act accordingly. I think you could see some impact on 8A contracting just because the sense out there that 8A is in flux and that it's being challenged, and maybe certain political figures don't like the program, and so maybe the safest thing is just to not use it as much. I don't know if that's true or not. It's just speculation on my part. But I think you're still going to see plenty of 8A sole source contracts this year. Again, there's no agency that I know that has said we're shutting that off. And the bill is, like I said, still sitting in committee.
I want to go back to your article that you've written recently titled on your FedLift blog, by the way, which is another great place to subscribe. But it's titled The 8A Program Suspension Appeals, a Primer for Your FedLift Launchpad blog. Some contractors got it in, others didn't. But as of now, there's been over 1,000 companies that's been suspended from the 8A program. And in this blog, you were talking about this suspension process and the appeals process. So you want to talk a little bit about that article in terms of what does suspension actually mean to a contractor? Well, what happens to future contracts? How does that appeals process work? And while we're talking about appeals, it's not only for suspended firms, but you can also appeal if you get denied, if you've applied to the 8A program. So it might be worth a mention, I thought.
Yeah, absolutely. I do have a new blog out there that just launched last month in January called the FedLift Launchpad, and it's where I write my articles first, actually, that later appear now on the GovCon Roundup LinkedIn newsletter, so you can go as a Substack blog. But it focuses on as Carroll said, in December, SBA issued this data call for 8A companies. There are about 4,300 active 8As at that point in time. It said you have to submit all this documentation within 30 days or so by January 5th, I think was the original deadline, and then pushed that back to January 19th, which was the federal holidays, Martin Luther King Day. Said you have to submit all your documentation by then. They gave them a couple more weeks to do it. After the 19th passed, the SBA immediately or almost immediately within a couple days suspended over 1,000 of those 4,300 8A participants from the 8A program, saying these participants had not timely submitted all the documents required by the December data call. Now, my understanding, talking from those who've seen SBA's database, is that of those 1,000 plus 8A participants that were originally suspended, a couple hundred of them the suspensions have already been lifted. And my speculation is, and this is just speculation, is that these are probably, and this is just speculation as well as hearing from a few voices out in the field, is at least some of these companies were ones that had tried in good faith to submit their documents in time, had potentially technical problems with the SBA's own system uploading it. And so I think that in that case, SBA, either of its own volition or because they got legal advice saying you're going to lose an appeal on this stuff, decided to reinstate it. So that means we probably have 800-ish or so contractors that I haven't looked at the data myself recently that are still suspended. And so this article was intended to say, okay, well, we suddenly have 800 suspended 8A contractors. Probably a lot of people don't know what that even means. What is suspension within the 8A program? What's the effect? How do you appeal a suspension of if you've been suspended from the 8A program? So suspension from the 8A program is a tool that SBA has available where it can essentially pause a company's ability to receive benefits under the 8A program pending potential termination for the program or potentially lifting that suspension once SBA is satisfied that the company is not a problem. That's historically been used most often, in my experience at least, preceding a termination, and often when the SBA discovers that a company gave false information in its application originally, that the company falsified either intentionally or negligently the information presented in its application, was never eligible for the program, should not have been receiving the benefits. And so SBA has to go through a special process when it terminates a company. It is a due process type process that has to play out. SBA can't just snap its fingers and terminate a company. Their company has legal rights to fight that termination, but SBA can kind of snap its fingers and turn off the benefits of the 8A program with the suspension. So historically, again, in my experience, when SBA is like, wow, this company is going to get terminated, we're proposing them for termination, they never should have been admitted in the first place, but we don't want them receiving more 8A contracts in the meantime. We don't want them taking advantage of the 8A program. Suspension means that the company still has its existing 8A contracts, and they're still obligated to continue performing those contracts. However, they're not eligible to win new 8A contracts during the date of that while a suspension is in place. And so anything new, they're not allowed to do, but they still hold on to your existing 8A contracts. It applies only to the 8A program. So it's important to differentiate it from a government-wide suspension or debarment, which would bar you from all government contracts. That's not the case here. This just says you're essentially temporarily no longer 8A. You can finish up your existing 8A contracts, just like you don't have to be 8A throughout the life of an 8A contract. You can graduate from that program and still finish your contract, but you can't get new benefits from the 8A program while the suspension is in place. And so when you're suspended from the 8A program, if that happens, you have the right to appeal that suspension. And the appeal goes first to an office called the Office of Hearings and Appeals, or OHA is the acronym, which is an office inside SBA that has one or more administrative law judges who are SBA employees, but who are tasked with acting independently, who will hear those appeals. Right now, to my knowledge, there's only one administrative law judge full-time at OHA, Judge Christopher Holloman, who's been there for probably 20 years or more. And to my knowledge, even though he is an SBA employee, in my experience, I've been in front of Judge Holloman many times when I was practicing law. He is fair-minded, and he does, I think, try to act independently, as that mandate would say. I also understand that because of the volume of appeals that may be pending here, SBA is maybe going to essentially lease judges from other agencies to come in and assist Judge Holloman in hearing these appeals. And so that's where the appeal would go. It would go to the SBA's Office of Hearings and Appeals. Has to be filed within 45 days of the notice of suspension. The late appeal will be dismissed. There's no ifs, ands, or buts. The judge doesn't have a right to hear a late appeal. Importantly, in these suspension appeals, the government has the burden of proof. The SBA has the burden of proof of showing that suspension is necessary to protect the interests of the government. And this all sounds like legally wonky stuff, but the burden of proof is really important. Usually when you're appealing something that the agency allegedly did wrong, you have the burden of proof. For example, if you are denied from the 8A program, you as the appellant have to prove the SBA made an error in processing your application. And remember those examples I talked about where a company was ineligible for the 8A program, they falsified information in their application, and now the SBA has an easy way to meet that burden. They say, the government's interest is protected when only eligible 8As receive 8A contracts. Hence, the suspension is necessary because this company is ineligible. They should never have been admitted in the first place had they not falsified their application. Right? That's a typical way the government would meet its burden in that case. But there have been many suspension appeals that I've looked at, and I went and did some looking after this whole incident came up with the 1,000 suspensions. in which the burden of proof was the deciding factor. The judge said, yeah, sorry, SBA, like we see what you're saying, but what you're showing us sounds like suspicion, sounds like innuendo, doesn't sound like real proof to us that the government's interest requires suspension. Victory for the suspended company. SBA, you're ordered to lift the suspension. And so these cases are going to be really interesting because the suspension was used as a broad tool to essentially punish companies that didn't, in the SBA's at least allegations, didn't comply with the data call. And so now the SBA has to convince the judge that the government's interest is protected only if those companies no longer have access to the 8A program's benefits. Well, what if one of these companies submits their data 2 or 3 days after the deadline? Okay, now you got all the data to assure yourself that we're eligible. How is our suspension necessary to protect the government's interest now? And I don't know, but I speculate that may be behind some of the reinstatements. Folks that had submitted their data or tried to submit their data on time, they couldn't do so because of the SBA system. I think the judges are going to be hard-pressed to say that the government's interest requires suspending those companies when they tried their best to submit on time and had trouble with the SBA's upload system for documents, and now SBA, you have the documents in your hands, right? So how is it protecting the government? So it'll be really interesting to see how these cases go forward. I think one of the key potential problems for the suspended firms is just the resource allocation over there. You've only got, again, to my knowledge at this point, one full-time judge who's an expert on these matters in OHA. Even if they bring in another judge or two from other agencies to hear these appeals, you could have hundreds of appeals coming all at the same time with maybe judges who are not experts in this subject matter hearing some of these appeals. So it could mean that some of these companies just don't get their day in court really for quite some time. And the suspension process says, the judge will issue a decision within 90 days when practicable, if they can. And, in my experience working with OHA, they try their best to meet those thresholds. But again, this is an office that published less than 100 written decisions in the year leading up to this. I don't issue a ton of decisions in the year. And so if they publish 90 decisions in 2025 and, ruled in 90 some cases, whatever it was, and now they've got, let's say, 500 appeals coming in, the resources allocation alone could mean that it takes a while to get those processed. Or maybe there'll be some way to consolidate those cases because so many of the facts are similar. We'll just have to see how this all goes forward. But that's kind of where things stand with respect to suspension, this tool that has always been there in the SBA's toolbox for managing the 8A program, but has never had its day in the sun until now. And now that's why I wrote the article to kind of let people know what suspension was about, the burden of proof, timelines, all those sorts of things.
When people are suspended from the program, let's just say it takes a year to have a decision, does that kind of temporarily pause their 9 years of eligibility in the program?
Oftentimes, yeah. And so that's going to be on a case-by-case basis. But oftentimes the company does essentially get the lost time back. And that's okay. Part of the lifting of the suspension is that, hey, we're lifting the suspension. When we suspended you, we're not going to say that year, now you're down 2 years. And so the rules are a little nuanced on that. But I think that in this case, my guess is that if these companies, a lot of them anyway, if they were to get their suspensions lifted following an appeal, they would probably be entitled to have that time tacked back on to their 8A application. I think it's also worth noting, although it wasn't in the article, that if these companies lose the appeal at OHA, that's not the end of the road. If you don't like the decision you get from OHA, it's considered a final decision by the agency, the SBA, and that entitles you to then go to federal court. And so we could see companies that say, no, now I want a federal judge to weigh in on this. I'm going to go to a federal court and sue the SBA in federal court. And that would be the next step for any company that loses this OHA appeal. But they have to go to OHA first. You have to get a final decision by SBA before you can appeal. And the OHA process is the final decision. I mean, it's a shame there's so many folks who are stuck in that situation. I wish that I had the magic, do this, say this, and it'll all be good. But unfortunately, we don't. You and I and everybody are just kind of waiting to see what happens at SBA. Obviously, as soon as I have any information that things are moving again, or if there any more news on that sort of front about what folks should do if their application is stuck in the system, I'll post that on my LinkedIn and probably on my blog over at the fedliftsubstack.com as well to keep people updated. But unfortunately, I don't have the magic bullet.
All right, awesome. Well, hey, thank you everyone for joining us. And again, if you are a member of our Govology community, you'll see updates on when we're going to be hosting our next episode of GovCon Roundup Live. We typically do these on the third Wednesday of every month. We also have the show posted typically around the first of each month there at govology.com/roundup. If you want to check it out, send an email out for you guys. And if you are not already on our distribution list and you want to get on, just send us an email at support@govology.com. And with that, this wraps up our topic of the day. Thanks again, Stephen, and we look forward to seeing everybody next month.
Thank you, everybody.
All right, take care.